And just a note, again, this will be recorded. I would love folks to be here live and to ask questions, right, and participate. But it will be recorded. So of course, you have to leave early or whatever. You won't miss out on anything. We'll send the recording and the slides and also a Habeas index that Kendra is going to go over at the end of the or after the presentation. All right, I think we're at over 50 participants. I'm sure folks will continue to roll in. We'll just get started with a brief overview and introductions. So for those who don't know CARE Coalition, although I imagine you at least do somewhat, so this is Capital Area Immigrants' Rights Coalition. We're located in DC, also have an office in Baltimore, and we represent primarily detained immigrants historically in this region around Washington, D.C., but increasingly all along the East Coast as our clients are transferred elsewhere. And our Immigration Impact Lab, where Kendra and I both work, increasingly does litigation all over the country that builds the law to benefit detained immigrants nationwide. So this is a training we are giving for our nationwide listserv, as well as several stakeholder groups we work with. I think there's varying levels of expertise in terms of habeas on this training. Some folks who might not know anything about habeas, which is great, and this I think will be helpful to you. Some people who do, but maybe are used to litigating in certain courts and now maybe want to be litigating in other courts. So all levels of expertise, that's great. We will assume a basic knowledge of immigration itself, seeing as I'm pretty sure immigration lawyers are immigration adjacent, but we'll try to cover the basics of immigration habeas law and federal court litigation as we go over the contents of this training. I'll also just note that feel free to put questions in the Q&A, the written Q&A. We will get to them as they come up, if appropriate, or at the very least at the end of the presentation. So feel free to put in questions there. If you have a pretty niche question to do with like an individual case, please just do that offline. You're more than welcome to email me. I'll put my email in the chat, and we're happy to talk to you offline. But if it's like an individual case and kind of a niche question, that's probably better for outside of this training. All right, so we'll get started with introductions. So my name is Austin Rose. I'm a senior attorney with CARE Coalition's Immigration Impact Lab. For 2 years, I was a fellow where I focused exclusively on habeas litigation. Now I do a little bit of everything with the Impact Lab, which in general, we do federal litigation to build the law to benefit detained immigrants. So that's petitions for review at the federal circuit court, amicus briefs to support other folks' litigation, district court litigation like mandamus and FOIA, and then of course, habeas in federal district court, as well as creating legal resources for advocates, trainings like this. And so I am happy to be here with my colleague, Kendra, and she can introduce herself right now.
Hey everyone, I'm Kendra Blandon. I'm a recent law grad from Georgetown and a first-year staff attorney with Lab. Pleasure to be here with you all and looking forward to talking about habeas.
All right, so I think we can get started, and we'll go into the basics here. So what is this training about? And I think it's important to frame this because habeas can mean a lot of different things, right? And so what we are talking about today is essentially litigating in federal district court to challenge a non-citizen's prolonged immigration detention on constitutional or sometimes statutory grounds. So that's a fairly narrow topic, although there's a lot in there. Just to clarify what we're not talking about appealing the merits of a non-citizen's immigration case, which you can't really do through habeas under current law. So we're not talking about appealing to the BIA or to a federal circuit court about whether someone should be eligible for asylum, for example. We're talking about their detention itself, which goes on parallel to to the merits case. The merits case, as we will talk about, is often relevant to a habeas petition, but it is not the direct question that we are concerned about. We are not also talking about criminal habeas. So, you might have heard of habeas in the criminal context, which is essentially a collateral appeal, saying challenging a person's criminal conviction. So that's not what we're talking about here. Immigration habeas, though similar in some regards procedurally, is quite different from criminal habeas. So we're not, again, challenging or talking about challenging a person's criminal conviction, although, again, their criminal conviction, if they have one, might be somewhat relevant to the habeas petition. And finally, we are not, though this is a legitimate claim that you can bring, we are not talking about challenging or seeking a non-citizen's release based directly on the conditions of their confinement, which most courts will hold is not a 2241 habeas petition. I won't get into what 2241 means, but we're really talking about challenging detention based on it being prolonged or otherwise unlawful. We're not talking directly about, for example, saying that the conditions of someone's confinement are unconstitutionally punitive or COVID litigation, right, which some of which was successful. We're not really talking about seeking release on those grounds, though again, conditions of confinement are relevant in some ways to this litigation. And then finally, just a note on regional focus. So as I noted at the outset, CARE Coalition, we're based in Washington, D.C. Historically, we have represented immigrants detained in Maryland and Virginia. There are no longer non-citizens detained in Maryland, which is great because Maryland banned ICE detention. We do still represent people in Virginia, but we're increasingly representing people all over the East Coast because folks are getting transferred to other detention centers. And then we also just broadened our focus because we recognize that we can build the law all together. So this is by nature of just our experience and focus. This is going to focus mostly on the law of the East Coast. That said, it will surely be relevant in general, regardless of where you're located. That the same is to be said for the habeas index that we're going to go over at the end of the training. It's going to be mostly focused on the East Coast. So Fourth Circuit, where we are, Third Circuit, 11th Circuit down south, Second Circuit to some degree, not much outside of those circuits. Although, again, if folks are in those areas and are curious to learn more, we could probably talk to you offline about those things, and maybe we could learn from you in that regard. Okay, so let's keep going. So how does habeas work? And what are we really talking about when we talk about immigration habeas? So essentially the steps, and this is, a little bit simplified and also based on, my own experience and our own experience. But the steps is that you file a habeas petition in federal district court. We're going to talk in a couple of slides, or maybe the next slide, about where to file. But in general, just as a preview, you're going to file in the federal district court where the person is detained physically. If the case is preliminarily viable, which it almost always is, the judge will order the government to respond to the petition. It's called an order to show cause. In some courts, it's a little quirky in terms of how that happens, but in general, the judge actually has to officially order the government to respond. It's a little bit different than a general federal complaint where there's a set response time of 60 days for the government or 21 days for non-government. The judge will give a certain amount of time. I've seen that be extremely short, right? Like sometimes they're used to that judges in the Eastern District of Virginia would order a response within like 5 days, which is awesome, right? Make the government work really hard. But, a lot of other courts will give the government a lot more time, especially courts in the 11th Circuit, sometimes in the third, right? So it could be up to 2 months. They could get the standard 60 days they would otherwise get. In general, the U.S. Attorney's Office, which represents the government in these habeas petitions in general, will normally get between 2 weeks and 2 months to respond, barring some unique circumstances. So the government then responds with a brief arguing, if they do want to argue, why the detention is justified or otherwise lawful. Then typically the non-citizen, or in our case, the attorney for the non-citizen, has an optional reply, right? Then sometimes there's oral argument, and this very much varies by court. So for example, in the Eastern District of Virginia, kind of by default, there will be oral argument. Whereas in a court, for example, like the Middle District of Pennsylvania, it's an outlier, at least in my experience, for there to be oral argument, and normally the cases will just be decided on the briefs or on the papers, as people say. And then the judge renders a decision on the habeas petition. Unfortunately, as we'll talk about and folks have probably seen, this can be unpredictable timeline, even perhaps more so than the timeline for an immigration judge, for example, to make a decision if they're reserving a written decision. A judge could decide right after briefing, but sometimes a judge could sit on it for months. And unfortunately, there's not a whole lot of ways to speed that up, although we can address that in some ways. So what is the outcome of a habeas petition like this? And this is very important to note. It can be a little bit discouraging to hear this if you don't already know, but it's also important to recognize why this is so important. So generally, we are doing habeas petitions for people who are ineligible statutorily for a bond hearing, right? So the default for detained non-citizens is that you are eligible for a bond hearing at the outset of your detention, at which you, as a non-citizen, has the burden of proving that you are not a danger and not a flight risk, which is counterintuitive. We'll, of course, talk about that. But many non-citizens are ineligible for bond for a number of reasons, because of a criminal conviction they have, because they have a final deportation order, because they are a quote unquote arriving alien. And in these circumstances, right, you're not eligible for bond. And so you actually have to go to federal court through a habeas petition and say, this is illegal to detain me without the government justifying it. And then you have to get the district court to order that. So it's often a two-step process. We were going to federal court first, getting some type of remedy, and then going and doing a bond hearing in immigration court. Of course, there are exceptions. Some district courts will just order outright release, but it is difficult to do so because of the statutory framework and because of just, I think, a general reticence on the part of judges, unfortunately, to do so. So the most likely outcome, if you're going to win a habeas petition and actually get a decision on it, is going to be a bond hearing of some sort. And then we will want certain procedures at that bond hearing, which can be quite relevant. We'll talk about that. For example, the government bearing the burden of proof at that bond hearing. And as I said, rarely would a judge order a non-citizen's conditional release as a remedy. The most common posture in which this would happen are cases under Zavitas v. Davis, which we'll talk about, where a non-citizen's removal is not reasonably foreseeable, but this is rare as well. And then just a note that is in general good, although sometimes can be bad. A lot of habeas cases, will moot out before decision, meaning that we won't actually get a decision from a federal judge on the case because the case becomes moot. So sometimes it becomes moot for a good reason, and that is that the non-citizen is released from custody. And this probably happens more for us, at least, than actually getting decisions. So a success for us in our eyes, for our clients, is of course getting them out of ICE detention. That's the goal here. And so that can often happen just by the pressure of a habeas petition. So for example, we could bring a habeas petition and talk to the AUSA, the Assistant U.S. Attorney, and they decide, you know what, we don't want to fight this. We're going to release this person, or we don't think we have a good argument against this. That does sometimes happen. Sometimes, though, they dig in their heels and they respond, right? So some cases will moot out positively, and maybe that is because of developments in the immigration case while the case is pending. And then unfortunately, some cases do moot out negatively in the sense that the person is deported before a habeas petition can be adjudicated. A common posture here would be a non-citizen loses at the immigration judge level. They appeal to the Board of Immigration Appeals. They file a habeas petition, but before the judge can decide on that habeas petition, due to unfortunate delays, the BIA dismisses the appeal and the person is deported. So unfortunately, some cases will moot out. But I think our motto is, you go for it, in the hopes that you can kind of beat the BIA if the BIA is going to dismiss, in terms of a race. And then of course there's always a possibility the BIA will remand or will actually grant your client relief. And then there's also, of course, situations where the government is the one appealing, in which case you're in a more of a position of power. So just to note that a lot of cases moot out. We do have a lot of case law that we'll talk about but there would be way more case law if so many cases didn't moot out. So we can go to the next slide. And there's a question about repeating the typical categories. We are definitely going to talk about the categories. So we'll cover that again. Okay, so where does habeas happen? This is a little bit disputed sometimes, right? So, but in general, and I don't want to discourage anyone from making a creative argument here, but in general, habeas venue under what's called the immediate custodian rule, which is a little bit artificial in this circumstance, to be honest, kind of a legal fiction. But in general, the venue lies where the non-citizen is physically detained, right? And as for folks who work with detained immigrants frequently, you may know that this doesn't often make a lot of sense because, for example, there's lots of detention centers that are actually county jails that contract with ICE to detain non-citizens, right? They're holding people for pretrial or on a criminal conviction, but then they're also being paid by ICE to detain folks for ICE, right? And so the warden of that jail does not have really any control over the non-citizen's detention. They can't do anything about it. They're just being paid to detain the person. So does it really make sense to sue that warden and have to sue in the district court where they're physically detained? No, it doesn't. But unfortunately, this is in general governed in Supreme Court precedent, and most courts will apply it. And so it is going to be difficult to appropriately put a case other than where they're physically detained. And so in general, we will just bring it where they're physically detained, for better or for worse. There is a creative argument that has been successful in limited circumstances that habeas venue should lie where the ICE field office is located. So an example would be the Philadelphia field office controls or kind of has authority over the detention of everyone in Pennsylvania. And so based on the Philadelphia field office, that would be the Eastern District of Pennsylvania versus the Western District, where a huge facility called Moshannon is. So the default is that you would have to file in the Western District where Moshannon is. You could maybe make a creative argument that it should be in the Eastern District. So this is where to file in general based on the immediate custodian rule. Again, this is East Coast focused and based on where we see the majority of our clients detained and where I think is more or less the landscape. I think this leaves out perhaps some places far up north, but I think it encompasses most of the ones along the East Coast as of now. So Farmville and Caroline are the two detention centers we've been working in for years. They're both within EDVA, Eastern District of Virginia, and that's, of course, the Fourth Circuit. In the Third Circuit, there is a huge facility called Moshannon that I'm sure folks on this webinar know about. There are more than 1,000 people detained there as of now. It's a former federal prison. That is in the Western District of Pennsylvania. This I think illustrates just how kind of arbitrary this immediate custodian rule can be. Moshannon is literally on the border or just over the border between two counties and therefore between two courts. And so there was when it first became an ICE detention center, someone tried to file a case in the Middle District of Pennsylvania because the county is in the Middle District of Pennsylvania. But if you actually look where it's physically located, it's in a different county, which is in the Western District of Pennsylvania. So you do generally need to file in the Western District for Moshannon. Pike and Clinton, which have been around for a while, those are both county jails that contract with ICE. Those are both in the Middle District of Pennsylvania. As a result, the Middle District of Pennsylvania has lots and lots of law, which we cover in the habeas index that we'll talk about. And then there is currently, as far as I'm aware, one detention center left in the District of New Jersey, and that's Elizabeth. And so, you would file that in the District of New Jersey. There's a facility called Batavia. Some people call it Buffalo Federal Detention Facility. Some people call it Batavia. That's in the Western District of New York in the Second Circuit. I believe that the facilities that are in the Southern District, like Orange County Jail, are not operating anymore, but I could be wrong about that. And if someone is on this call and knows, feel free to correct me. And then Stewart and Folkston are two big ones in Georgia. Stewart being in the Middle District of Georgia and Folkston being in the Southern District. So again, this is just kind of a summary of the detention centers we often see and where you would have to file if you are trying to comply with the immediate custodian rule and not trying to make an ambitious argument otherwise. We can go to the next slide. Orange County Jail is still active. Thank you for clarifying. I did not realize that. So thank you for clarifying. So there you go. SDNY is still the venue for for that. I think you clicked through a couple times. All good. Um, Okay, so we're going to now get into the an overview of immigration habeas law. Again, I think some folks, including the folks that answered my question about Orange County Jail, probably know a lot about this, right? And so, but we're going to try to, make this accessible to everyone, and maybe we'll, cover some things that will still be helpful to those who have more expertise. Again, this is mostly focused on East Coast. So we will start with a little bit about detention authority before I hand it over to Kendra. So in general, we are dealing with 4 different statutes or provisions in the Immigration Nationality Act. These are the cites to the US Code. And in general, there are more or less 4 categories of folks, of detained folks. And what kind of habeas claims exist more or less correspond to the statute under which they are detained. So the default, as we talked about at first, is 1226A discretionary detention. So these are folks who are bond eligible. And as we'll talk about, these are going to be claims more about who bears the burden and some prolonged detention claims. A very common situation is 1226C mandatory detention based on a criminal conviction. So you're ineligible for bond because you have been convicted of an aggravated felony or a certain deportable offense. And therefore, you don't even have an opportunity for a bond hearing and you need to go to federal court to get one. Very similar to mandatory detention, but slightly different posture is mandatory detention of quote unquote arriving aliens. We of course don't endorse the use of the term aliens. So we will try to refer to them as, applicants for admission, but that's the statutory term. And there's claims that are similar in large part to mandatory detention 1226C claims, but are a little different because there's certain parole procedures available to those folks that aren't available to others. So these are all under pre-order because these are all statutes that govern the detention of people who do not have a final deportation order. They are pending proceedings, and that can be relevant for better or for worse in a lot of ways to habeas law. So that's the pre-order posture, which Kendra is going to go into more detail in a second. Then there's the post-order posture of folks whose detention is governed by 8 U.S.C. 1231A. There's a 90-day removal period, and removal period can be kind of a complicated term we'll talk about. That is mandatory detention, supposedly, for 90 days. So in other words, ICE has to detain during that period. And then after that, there's discretionary detention. So there's a whole body of habeas case law that we're going to break into more or less 3 categories that has more to do with post-order than pre-order. So that's the kind of overview. Kendra is now going to talk about some pre-order claims, and then I will come back to post-order to talk about those.
Awesome. So let's go ahead and start talking about people who are still in proceedings. They have not received a final order of deportation. So we're going to talk about the as-applied due process challenges for those in 1226C and 1225B postures. Then we're going to move into challenges to discretionary detention for people who are bond eligible but detained under discretion. And I'll also just note that which statute applies at any given time can be an issue of litigation as people move throughout the proceedings. They can be detained under different statutes for different time periods. So please just note that sometimes it just might be something that you have to litigate and look more into if it's not very clear which statute is governing your client's detention. So first, let's talk about 1226C, which governs mandatory detention for those who have criminal convictions and are awaiting a removal order. The 2 Supreme Court cases most on point are Demore v. Kim in 2003 and Jennings v. Rodriguez in 2016. In Demore, non-citizens challenged the constitutionality of this statute that permitted their detention without bail. The Supreme Court rejected an argument that detention under 1226C is per se unconstitutional, rejecting a facial due process claim. However, they noted that The statute does not bar courts from granting habeas relief as it applies to each detainee and as to applies to each non-citizen. And so Damore left the door open for people to bring as applied due process challenges. This issue was again before the Supreme Court in 2016 for the case of Jennings. Before it got to SCOTUS, the Ninth Circuit shunned an interpretation of the detention statutes and held that there's an implicit 6-month time limit on a non-citizen's detention. So the Ninth Circuit wanted to say that if detainees with criminal convictions awaiting a removal order are in detention for longer than 6 months, that detention is now unreasonable, prolonged, and unconstitutional, and they developed that per se rule. The Supreme Court reversed, holding that there's no clear time limit on detention, and it remanded for the Ninth Circuit to evaluate as applied due process claims. So put simply, while SCOTUS agrees that prolonged detentions of a non-citizen awaiting a decision can become unconstitutional at some point, they leave it up to each circuit and really up to each court to determine what that point is, and up to each judge to apply the law to each individual. Some notable post-Jennings precedent to note just for each of these circuits is Herman Santos v. Warden, Sopos v. U.S. Attorney General, Portillo v. Holt, and Cabral v. Decker. We've put together a habeas index that goes into depth on each of these cases, and it highlights published and unpublished cases in each circuit and each court. And I'm going to walk you through that at the end of that presentation. And we're going to use Herman Santos as an example. So for now, the important thing to understand is that there is no bright line federal rule, but each circuit, most of the circuits, some circuits have developed a balancing test. Each circuit and each court is going to be different, but these are the factors we want you all to be thinking of, and they might pop up depending on where you're litigating. So all courts will consider the length of detention, how long someone has been in ICE custody. For people who have been in criminal custody and are then transferred to ICE, we are specifically looking at the length of their civil detention while they're in ICE custody. Courts will also consider the likelihood of continued detention, essentially saying, like, how much longer is this case going to drag out? How much ping-ponging has there been between the IJ and the BIA? And what's the likelihood that they'll be detained much longer? Courts will also consider the reasons for delays, including whether their applicant caused delays, like continuances, asking for additional time to brief materials, or whether there was any bad faith on the government's part. The courts will also consider conditions of confinement, whether the immigration detention center operates like a criminal facility. Some detention centers like Folkston in Georgia have already been declared that essentially it's the same. You can call it an immigration detention center, but it looks exactly like a prison and it operates like a prison. So some courts have said that specific detention centers operate like criminal centers, and so that one factor will weigh in the non-citizen's favor. Then some courts will consider the length of immigration detention versus the length of criminal detention. If someone served a criminal sentence of 6 months and as a result of that criminal detention are detained by immigration for more than 6 months, then it becomes more and more likely that the immigration detention is operating in a punitive measure and is becoming unconstitutional. Courts will also consider the likelihood of a removal order, the viability of a merits case, and they'll also consider the nature of a criminal conviction. We're talking right now about the habeas petition to ask the district court judge to order a bond hearing. We'll talk more about the bond hearing at length, but at the bond hearing, that's really where the non-citizen and the government will go back and forth on whether someone is a flight risk and whether they're a danger to their community. So in general, that inquiry is not relevant to whether someone is eligible for a bond hearing in the first place. But some courts, especially in the Second Circuit and sometimes in the 11th, will consider the nature of the criminal conviction before deciding whether or not someone is eligible for a bond hearing. Next, let's talk about folks that are in a different procedural posture, people who are in 1225B proceedings. This is for arriving aliens, statutorily referred to as this is for applicants for admission in the statute called arriving aliens. So similarly, the Supreme Court in Jennings struck down a constitutional avoidance claim for 1225B, holding again that this detention is not per se unconstitutional, but that non-citizens can still bring as applied claims to themselves. The Supreme Court again reached this issue in Thurigasiam, a Supreme Court case in 2020 that considered the case of a Sri Lankan national who entered without inspection, went through expedited removal proceedings, but sought to contest his removal by reasserting a fear of persecution based on nationality and political opinion. So he was transferred from expedited removal proceedings to full removal proceedings for the consideration of his claim. The Supreme Court reaffirmed that applicants for admission have limited due process rights in the United States. In the matter of MS, the court considered the constitutional due process rights of applicants for admission who move from expedited removal proceedings into full removal proceedings. Unfortunately, the Supreme Court overruled the BIA's decision in matter of XK, which held that all non-citizens in such posture are eligible for bond. However, the precedent as it stands post-Jennings, post-Supreme Court, is that they are eligible for parole, but the court in Mabaliado concluded that parole remedy is not constitutionally adequate for applicants for admission like the petitioner, who had been detained for nearly 2 years while exercising his right to seek fear-based relief. The court ordered a bond hearing with the burden on the government. We'll get more into the burden of proof in just a few slides. In Pierre Vidal, the Middle District of Pennsylvania considered the case of an applicant for admission who was being ping-ponged between the IJ and the BIA, again, for about 2 years. He had applied for parole, the only remedy available to him at the time, but was denied twice. The court concluded that his detention had become unreasonable and ordered a bond hearing. Excuse me for the sirens. And Let v. Decker, the Southern District of New York, unequivocally held that applicants for admission, aka arriving aliens, have sufficient due process rights to challenge their mandatory detention. And in a prior case, Saju v. Decker, they concluded that in order to determine whether detention has become unreasonable, the court must weigh 3 non-exhaustive factors, again, thinking about the balancing factors from different courts. And in New York, they held that those 3 factors are the length of detention, whether the petitioner is responsible for delay, and whether the petitioner has asserted a defense against removal, in this case, an application for asylum. The appeal was vacated and moot, but these cases are still really essential habeas law. And lastly, turning to Padilla v. Ice in the Ninth Circuit, it was vacated and sent back down to district court, but the case is still essential precedent. Here, a class of applicants for admission filed a suit after they passed their credible fear interviews but remained detained. The case also arose under the backdrop of family separation at the border, and the court notes that the Supreme Court has repeatedly held that non-punitive detention, including civil immigration detention, violates the Constitution unless it is strictly limited. So after Padilla, applicants for admission can contest their prolonged detention under Matthews, which asks the court to consider, again, these balancing factors. In Matthews, those factors are a petitioner's liberty interest, the risk of erroneously depriving them of that liberty through the processes already used, and the government's interest, including the fiscal and administrative burdens of the alternatives, like a bond hearing or alternatives to release. So if for folks who've made it through this process, who are granted bond, a remaining question exists of who's going to bear the burden of proof and persuasion at the bond hearing. In the minority of courts, the district court judge will order the burden to be on the government by clear and convincing evidence that a petitioner is a flight risk or a danger to the community. If the government successfully demonstrates that a non-citizen is one or both, the non-citizen will be denied bond, but may be eligible for another bond hearing in the future. Important to note that some courts have held that there is no right to a second bond hearing, but we will give a few more tips on how to litigate that. Other courts rule differently, like the Fourth and the Ninth Circuit, which conclude that since non-citizens have limited due process rights, it is their burden to prove by a preponderance of the evidence that they're not a flight risk and that they are not a danger to community. Note that this preponderance of the evidence standard is less rigorous than the standard used for the government, clear and convincing evidence. Non-citizens in this posture with the burden on them may want to offer letters from loved ones, evidence of complying with the laws, and evidence demonstrating their good moral character. Please also note that sometimes district court judges order bond hearings, but their order is unclear as to who will carry the burden of proof and persuasion. So sometimes you'll have to brief who should bear the burden in your before the immigration judge. So what happens to applicants for admission who are granted a bond hearing but later lose? Unfortunately, there's no bright line rule that non-citizens are entitled to a second bond hearing every 6 months. That argument was expressly foreclosed by Jennings at the Supreme Court. And yet, even to make matters worse, in Borbat, the Third Circuit said that they need not decide when, if ever, the due process clause might entitle an alien a second bond hearing, absent a clear allegation of a constitutional defect in their first bond hearing. We will just also note that habeas law is quickly changing, and so we want to highlight some favorable case law. In Velasco, the Second Circuit reevaluated the case of a man who was detained for 15 months after his first bond hearing where he bore the burden, and he lost. The Supreme Court held that the longer the duration of detention, the greater the deprivation of his private liberty interest. So not only did they order a second bond hearing be conducted, they shifted the burden from him to the government. And in Cardona Tejada, the Eastern District of Virginia ordered a second bond hearing. While it kept the burden on the non-citizen, it expressly ordered the immigration judge to consider alternatives to detention, like supervised release, with frequent ICE check-ins. And so those are just some of the things to consider in terms of who will bear the burden at a bond hearing, as well as if you lose the first bond hearing, what are the things you should be thinking about in the second? And now back over to Austin for a discussion on bond hearing procedures.
Thank you, Kendra. So yeah, that was I know we threw a lot at you there. It can be confusing for sure. And of course, there's not, I think, as Kendra said, always straightforward rules. But it's a lot about how you advocate, right? So there's a lot of good case law out there, like Velasco v. Lopez, right? Or Velasco Lopez v. Decker. It's a great case out of the Second Circuit, one of the best I've seen. So thanks to the Second Circuit advocates if you were, involved in that. But there's also, some bad case law, including the Fourth, where we were part of the litigation for Miranda trying to get all bond hearings, right? Not just an as-applied claim, but all bond hearings. We wanted just a preliminary injunction placing the burden of proof on the government and all bond hearings in the District of Maryland, but unfortunately that was overturned by a conservative panel of the Fourth Circuit. So I'm just going to talk a little bit about more or less the bond procedures and really here. So Kendra talked a little bit about, some facial due process claims or statutory claims about who should bear the burden in general, right? So more of a like a general rule. So this here I'm referencing when you bring a habeas petition, an individual habeas petition or a group one, I suppose, and the court orders a bond hearing, what is the court likely to do with that bond hearing in terms of the procedures at it? And this can be very important, as we talked about, right? Because unfortunately, with it being very difficult to win outright release from detention, you will often want to set yourself up the best as possible for your client to be released, and that is holding the government to their burden, right? So especially when the government is, maybe making allegations without a real criminal conviction, or they are claiming someone is dangerous, quote unquote, for a conviction from 20 years ago. You want the government to bear the burden to have to show they are now dangerous, because when the burden is on the petitioner, as a lot of advocates know, it's very difficult to show you are not dangerous. In fact, it's rather counterintuitive. So in the Fourth Circuit, unfortunately, it's more or less mixed. When a district court in the Fourth Circuit, and when we say the Fourth Circuit, at this point, it's really just Eastern District of Virginia, right? That's the only place people are detained by ICE in the Fourth Circuit as of now. It's a mixed bag. So some district, it more or less correlates, unfortunately, to whether it's a more progressive democratically appointed district judge or whether it's not, right? And so sometimes courts will order a bond hearing on due process grounds or otherwise, and they will place the burden on the government by clear and convincing evidence. But sometimes they won't, right? And so we have to fight that issue each time, which is annoying, but it's a necessary thing. The one good thing in the Fourth Circuit is courts have, especially in EDVA, ordered immigration judges to expressly consider alternatives to detention, or, for example, like conditions outside of monetary bond. And that can be helpful when someone might be unable to pay a bond, or to show that if there's a concern about danger, that you can place extra conditions on them in addition to bond. Third Circuit, in general, under Herman Santos, right, which Kendra covered, in general, if a court orders a bond hearing on due process grounds, the burden is probably going to be on the government. That's what Herman Santos says. That's what it should be. I have found, and folks may have seen this, the government somehow continues to argue this. And so even if they acknowledge that the detention is unreasonably prolonged, they might still say that the burden should be on the petitioner. I think that that's an absurd argument, but they are continuing to raise it, so you might still have to brief it. And that's actually Third Circuit law, Herman Santos, so it's a little bit easier. In the Second Circuit, as I understand it, there is no Second Circuit itself precedent directly on prolonged detention yet, and so there's also no firm case placing the burden of proof on the government in those cases. But as I see the case law, and feel free to correct me if I'm wrong, it seems like most courts, vast majority of courts, are ordering bond hearings with the burden on the government by clear and convincing evidence, and often ordering the immigration judge or the government in general to consider alternatives to detention and ability to pay. And then finally, in the 11th Circuit, and this is perhaps not surprising, even when you prevail in a court like the Middle District of Georgia and get the court to recognize that detentions are unreasonably prolonged, often the burden is still going to be on the petitioner at that bond hearing, and there's not going to be other requirements. So these are issues that we continue to litigate to try to make it more widespread and accepted, as it should be, that when there's a due process violation, the government needs to justify detention, not a counterintuitive thing where the petitioner has to say they're not dangerous or not flight risk. We can go to the next one. Okay, post-order habeas claims. So these ones are near and dear to my heart, and they might be a little bit less familiar to folks than the pre-order claims. Just a kind of primer here that I'm dividing these up into three types of claims as I understand them. You could argue that they're all the same in a way. You could also probably divide them into more categories, but this is like the best way I found to describe it. This can be quite exceptionally complicated, these post-order claims. And again, this is based on our experience in care collection, our litigation. So I'm sure there's other creative claims out there. And if people want to share those, please do so. So let's jump into it. All right, so first we need to figure out, and apologies, this is somewhat technical, but I think it's a really important thing to note. Again, you'll get these slides, you'll get the habeas index. So when is there a removal order, such that when do we know when we're pre-order, like Kendra was talking about, and when are we post-order? Because it matters often which test is going to be applied. So straightforward thing, and I think as most people understand, there's a final order when an immigration judge denies the case, denies relief, orders someone removed. They appeal. They either don't appeal, then it becomes final within 30 days, or they appeal and the BIA affirms and dismisses the appeal. obviously then someone has a final removal order, and their detention is now governed by the post-order provision. Another one, which is now clear, for better or for worse, although previously was disputed, is people who are in reinstatement or have a reinstated removal order and are in withholding only proceedings. So the way this happens is someone gets deported from the United States, physically deported, they come back, the government reimposes that reinstated order, reinstates the prior removal order, and then their detention at the moment that they are redetained, if they are redetained, is governed from the beginning by 1231. And there's really no dispute about that anymore after the Supreme Court's decision in Guzman Chavez. So folks in reinstatement, their detention is governed by 1231, and that can make some complications that we'll talk about. Another thing, this is less common, there's a thing called a final administrative removal order, or FARO, not like the grain Pharaoh. And that is, it's a way that the government can order someone removed summarily based on an aggravated felony conviction. My sense is that the government could do this more than they do, but they do it. It's almost kind of random. So we have a lot of clients actually they get their final removal order while they're still in criminal custody, and by the time they enter immigration custody, they already have that far out. And again, they're post order. Perhaps there could be an ambitious argument they're not, but that's probably what's going to happen. And then this is one to be on the lookout for. I think this is arguable, and I'm not sure assistant U.S. attorneys would grasp this argument in order to make it. But technically, under some governing law, if you were to appeal to the BIA and then the BIA remands only to your eligibility for withholding only relief, so they don't disturb the removal order, but they just say the IJ needs to reevaluate whether you're eligible, for example, withholding removal or CAT, then technically I think at least your removal order is final at that time. And then there'd be a question as to whether your detention is governed by 1231. So that's where you're generally in post-order territory, such that we are going to then talk about those post-order claims. Pre-order, straightforward. When you appeal and that appeal is pending, you're pre-order, right? Unless you were post-order even before the immigration judge decision. So it's not a final order while it's on appeal at the BIA. And then if you go up to the federal circuit court and the circuit court orders your removal stayed, so the circuit court grants a stay of removal as opposed to a different agency. The BIA doesn't count, it has to be a circuit court. Then that stay in general is going to render your detention pre-order again, which can be kind of confusing. So essentially you're pre-order, then you're post-order for like a couple months, and then you're pre-order again. And that can be relevant because of the type of claims you raise. I won't get into the weeds on this, but like in general, in the 4th and 11th Circuit, you would have to get just procedurally a permanent stay of removal. In the 3rd Circuit, as I understand it, you can often get a temporary stay because that temporary stay of removal remains in effect for perhaps several months while they actually adjudicate the real stay motion. And in the 2nd Circuit, this is somewhat disputed, as I understand it. It's currently at the 2nd Circuit, this issue. But in general, district courts have held that when you're subject to the forbearance agreement, where ICE has agreed in the 2nd Circuit not to remove you pending a petition for review, that still counts as pre-order. And this is just some case law as to those points. Leslie in the 3rd, Farah in the 11th, Echevarria, I'm not sure if I pronounced that right, in the 2nd, and in EDVA, Bobby Barr. We can now get into the meat of these post-order claims. So the one that perhaps folks are the most familiar with is the famous Supreme Court case Dividus, some people call it Zabidas. This is a case from 2001. It's kind of the seminal starting point for immigration habeas law. And basically it held that for people who have been deported from the United States, but they have not been deported due generally to like bureaucratic issues or strains in diplomatic relations between countries, or maybe they're stateless, they haven't been deported. And the question is like the extent of the government's authority to hold them indefinitely. So Zavidas said that the government can hold people, it's presumptively reasonable for ICE to hold people for 6 months after the removal order becomes final, and then after 6 months, ICE must release the petitioner if the petitioner can show that the removal is not reasonably foreseeable. And the Supreme Court case Clark extended this to all non-citizens, regardless of their original status. So the kind of posture here, right, is like perhaps you are, for a while it was happening for folks from Cuba, right, where there was so little diplomatic relations between the United States and Cuba that the embassy of Cuba was not going to accept someone back. They weren't going to be able to get travel documents. They were going to wait. This used to happen a lot for Vietnam. It happens currently frequently, sometimes to folks from Venezuela. These are just some examples. And so that's the typical facts. And that was the facts of Zavidas. These people who their case is over and they're just waiting to be deported. And there's a question of their indefinite detention. So that's more or less how it works. Unfortunately, this is again my anecdotal experience of some people might have other experiences. Unfortunately, Zavidas petitions often result in deportation rather than release. So when you file a Zavidas habeas petition, the government then gets around to deporting you when they weren't doing it before. But there's obviously a chance to release. So typically you only want to do this if the person has decided, understandably, that like, I just need to be out of ICE custody because of how horrible it is. And I would rather go to my home country than stay here. Because that can be a risk, unlike in the pre-order context, where it's not necessarily going to change the outcome. So that's Zavidas. And that straightforward situation is a type of habeas petition that you can raise. But the logic of Zavidas then ends up applying to these other situations, which are slightly different. So this is a very somewhat complicated and evolving area of the law, one that Care Coalition has been heavily involved in. And this is going to get pretty in the weeds. So forgive me for that. So there is a question for people who are in post-order detention, but they're in ongoing proceedings. So they're not like the Zavidas situation. They're more similar to folks pre-order. They're still waiting for the immigration judge or the BIA or whoever to decide their case, but they happen to have a removal order because they're in reinstatement, or they have a final administrative removal order or something like that. So we know that those folks after Guzman Chavez are detained under 8 U.S.C. 1231, so they're not per se eligible for bond. Unfortunately, some courts had held previously that actually these folks are considered pre-order because of the posture of their cases, but that argument has been pretty much entirely foreclosed by Guzman Chavez. And then there was a Supreme Court case, Arteaga Martinez, last year, summer 2022, and that overruled this great precedent out of the Third Circuit and the Ninth Circuit, saying, similar to Jennings, that there's a automatic bond hearing. You have to have a bond hearing after 6 months, read it into the statute, constitutional avoidance claim. So that is no longer the case. So you're not automatically bond eligible. You don't automatically get a bond hearing after 6 months, but arguably there is still an as applied due process claim, just like the other ones. The difference is just that you're dealing with the fact that you have a removal order, and you're dealing with ICE's custody review procedures that govern these folks and their adequacy. So this is a very, as I understand it, a very limited body of case law so far, because Arteaga Martinez just came down last year. I believe ours was the first, and unfortunately we lost in EDVA, and this is pending appeal at the Fourth Circuit. We are arguing on December 6th on this. And that involves the detention of a non-citizen reinstatement for 4.5 years, which is, just totally absurd length of detention, and whether they have a right to a bond hearing on account of their prolonged detention, also is a Zavidas claim. There were two really great decisions. Shout out if the folks are on this call who were involved with them in this posture, which is essentially what we were trying to get with our case, but unfortunately we got a bad decision. Michelin v. Odo from August of this year, and Cabrera Galdames in February of this year, both finding that for people in prolonged detention and withholding only proceedings of some sort, they on due process grounds must get a bond hearing with the burden on the government by clear convincing evidence. So those are great cases. And then in EDVA, we're trying to get good circuit court precedent on this issue. And then this is an issue that's pretty niche, but we are currently litigating it in EDVA, and you may have seen me bothering you in your inboxes about this issue, or sending out a survey, or talking to you about it. This is an issue that is incredibly frustrating. This is when people win their cases, right? And then ICE still detains them. And the reason supposedly for doing so is that you win a final grant of withholding or relief in a convention against torture, because you were probably ineligible for asylum, and these are the only forms of relief you could get. But the way those forms of relief work is that you get a removal order, and that removal order is withheld or deferred. And so because you're subject to the post-order custody review procedures, then ICE can apply those procedures, and they can seek third country removal, right? So they can say, okay, we can't deport you to El Salvador, for example, because you've been granted cat relief, you're going to be tortured there, but we could deport you to Honduras in theory. The problem, though, is that this never happens. This almost never happens. And if it does happen, it's probably because someone is a dual citizen or has a strong tie to another country. It's not the case that countries just randomly accept the deportation of people from the interior of the United States to them without any tie. So we have been challenging on an individual basis, now on a class basis, this practice of ICE holding people for 3 months or more while they allegedly seek their country removal. And in a way, this is a Habeas claim. You're arguing that folks' removal is not reasonably foreseeable because they can't be deported to their home country. We already know that. And they're not going to be deported to third countries. It's not going to happen. And ICE is supposedly reaching out to those countries, but we know nothing about the progress of those requests or whether they're even viable. So we do have pending class litigation on this issue, as I talked about. I'm going to share a way you can help in that with that in the next slide. There's a question: do the factors discussed for pre-order cases apply to post-order cases under 1231? That is a great question. So yes and no. If it's a straightforward Habeas claim, so someone who hasn't been deported for after 6 months of post-order detention because of bureaucratic barriers, then you're just focused on, arguably, is removal reasonably foreseeable or not. What Habeas says is that if it's not reasonably foreseeable, they should release. The government might talk about danger, flight risk, all this stuff. It's irrelevant. That said, in the context of people in ongoing proceedings, so the previous slide I was talking about, who are just happen to have a removal order, I think that there are two claims. You can raise more of a Habeas claim and say removal is not reasonably foreseeable, but it's more similar to the pre-order situation because they are in ongoing proceedings, and in which case those factors that we discussed, that Kendra discussed, do make sense, right? So for example, in our case, we were arguing that under the Matthews analysis of due process analysis, that the liberty interest is great and the government's interest in detention without bond is low. We also tried to apply the factors for EDBA to their detention because that makes sense. So in a case like that, within ongoing proceedings, yes, I think you would bring up those factors, though the government may dispute whether they apply, if that makes sense, because of the removal order. Then we can go to the next slide. That's a great question. Also, Lisa, has there been any FOIA litigation around obtaining records ICE process and allegedly finding a third country? Yes, we just, in fact, filed that 2 days ago. So we have a pending FOIA request there's a lot of different issues going on here. So we have had a pending FOIA request for a very long time on what is the current policy on this, because for a while they reiterated again and again and again on a national level that folks in this situation, when they've been granted relief, should be released barring exceptional circumstances. That's clearly not what a lot of field officers are doing now. So we have FOIA litigation pending on trying to get those policies that they clearly are trying to keep from us. There's also some data on there on how uncommon this is. And so we have numbers from the past. We're trying to get updated numbers. Just to give you a sense, though, it's about 3% of people who are granted withholding or CAT are actually deported to a third country. And I suspect that many of those people are people who maybe are granted withholding or CAT and then it's later reversed or terminated, or people who are dual citizens. And so the number may be even smaller. We're trying to get updated numbers on that. And then finally, we have done some individual FOIAs for our clients about finding what did ICE actually do in their case when they were reaching out to third countries. Our understanding is that they literally like send emails, right? It's not real, like really, they're not actually searching. They're just kind of putting out feelers. If you have clients in the situation, I think it would be awesome to FOIA that and try to find out, because if we can show how futile this is, I think that helps the habeas claims. So I'll move on from this in a second, but just note there is a survey. I'll send these slides out. I'll send a survey. If you have ever had a client who has been detained for any period past a grant of withholding or CAT relief, please fill out that survey, whether they're currently detained or were in the past and were released in the last couple of years. That would be really helpful for us to know. We're trying to understand the national landscape of this. And so far, we've gotten, responses from all over the country. There's also a AILA practice pointer. If you're not an AILA member, I'm happy to send you a PDF of that. I will also share that in an email. We have compiled the national ICE policies on this issue so that when you're talking to, like, for example, a deportation officer, you can say, hey, look, this is the policy. Why are you not following it? And then finally, you could, of course, file individual Civitas habeas petitions in this posture, making the arguments that we do. And there's, we have published the redacted complaints that you can kind of do that. Of course, I'm more than happy to talk to people about this type of litigation as it benefits our class and your clients. All right. So, do we have a database of habeas cases in each of those districts? So essentially, yes, we are going to share the compilation at the end of habeas law. In terms of, Kendra is going to go over that, at least for East Coast. For templates, we do have templates, and you can email us individually, and we might have like a template, redacted template, an example that we could send to you. We do not have those published because it's a little bit dependent on the posture of the case. But we can send you templates, and I will put in my email in there, which you guys will have eventually. All right, so we're going to go through the nuts and bolts of kind of how to file a habeas petition. If you are not interested in this, feel free to log off. We are going to talk about the habeas compilation at the end if you want to get a kind of primer on that. But I think this might be helpful just for if you've never done this before, just like procedurally, how does it go? And I'll try to keep it brief, but I think that that's, helpful. All right, so drafting the petition. So in general, the way this will work is that you will, more or less break your habeas petition into these sections, more or less self-explanatory. You do want to be very clear about who the parties are and what you are asking for. The parties here, and I think maybe I talked about this in the next slide, you are suing in general the warden, quote unquote, of the ICE detention center where your client is detained. You're suing DHS or its subsidiaries, and you're suing the attorney general because they have to be served with all of these anyway, and because that within the attorney general is the immigration courts. So in general, those are the people you are suing, and in general, the government representative for those folks is the assistant U.S. attorney. And so just some strategies. Again, this is kind of self-explanatory. I think it's important for example, if you know that the case is kind of governed by certain factors, you want to make sure to cite to cases, and I think our habeas index will be helpful for this, that speak to that factor and say, this person was detained for this long and he was granted habeas relief, and my client's the same. And this client was detained at Pike in PA, and this court has held that Pike's detention is punitive. It resembles criminal incarceration, and my client's detained at Pike. So I think it's really helpful to point to that case law, because otherwise I think it's easy for judges to kind of not even know about what the body of case law is, because this is a kind of unique issue. So it's very important to do that. Arguing in the alternative, obviously very important. You could seek outright release, but then say, if not, release a bond hearing with these procedures, right? It's important that you don't concede or say more than you need to. An important example here is your client's criminal history, as Kendra mentioned, barring like certain circumstances, it's not generally directly relevant to the habeas petition itself. So like if your client is detained subject to mandatory detention, then sure, you'll probably mention the conviction that makes them subject to mandatory detention, but you don't need to discuss any other criminal history. You don't necessarily need to get into that. Of course, mitigating factors are great. So if you want to talk about, rehabilitation or whatever, that's fine, but you don't need to lay out all the facts about your client's case if they're not directly relevant and if they're not helpful to you. Frankly, the government might know about them and you might want to kind of preemptively discuss them, but you don't need to put forth everything about the case. And then finally, anticipating the government arguments. So you do want to kind of know, this is what the government's probably going to say, and how am I going to argue against that? So a very common situation is the government is almost always, in cases involving prolonged detention, going to make up some argument about how it's your client's fault that they've been detained this long. So they're going to be like, well, your client, they sought continuances, or they're the ones who appealed, or something like that, right? There's a lot of case law out there that says seeking remedies to which you're entitled does not diminish your due process, right? So like if you're appealing your immigration judge decision, that does not mean you have any less due process rights. It's sometimes important to get ahead of those because the government just kind of makes the same arguments every time. So we can go to the next one. And then before filing, so it's important to note, again, this is kind of the nuts and bolts, that you will need to be admitted in some form to the court that you are filing in. This would unfortunately be a barrier. Some district courts, you can litigate in them if you're barred in any federal court. Some district courts require you to be barred in the state in which that court resides, right? So for example, you can only litigate in the Middle District of Pennsylvania if you're barred in Pennsylvania. You can do pro hac vice, right, through local counsel, but that's still going to involve pro hac vice doing something preliminary, right? So it's just important to know at the outset, you generally can't just file something unless you know the procedures for filing in that court. The documents that you're generally going to include in a habeas petition, and again, this is subject to your own knowledge of the case and your own expertise and insight, right? But this is in general what we would include. Obviously, the petition itself, making the legal arguments, a civil cover sheet, this is a procedural thing, a proposed order, so basically like giving the judge what you want the judge to do, and then exhibits. Again, you do not need to include everything about your client's case, but in general, you're going to want to include a declaration about their experience in detention. Doesn't need to talk about the merits of their immigration case unless that's directly relevant. But, I think it's important to describe, especially if conditions of confinement are a relevant factor, how hard has it been for this person to be separated from their family and to be in this detention center? I think not only is it relevant legally, it also, garners sympathy with the judge. Immigration docs doesn't have to be everything, but, generally you would submit the NTA if your client got an NTA, notice to appear, to show what detention provision they're detained under. Criminal documents, again, only if helpful. So maybe you want to show, someone's compliance with parole or something like that, right? But you don't need to, submit police reports. The government might do that. And if the government does do that, then you can argue, listen, this is not what we're talking about right now. That's for the immigration judge to decide whether my client is a danger. The only question here is whether his due process rights have been violated. And then, of course, equities, talking about, mental health issues, conditions of confinement. And sometimes it might be relevant to describe what conversations, if any, you've had with ICE so far. You don't have to exhaust your administrative remedies, but it might be helpful to show, listen, I've tried to request release with ICE and they're not doing it, right? Like something like that. So then we can move to the next one, and then we're almost to the habeas index. E-filing through PACER. Okay, so this is where I'm going to talk about the parties. And that's a great question. So from Jessica, in EDVA, do you ever do attorney declarations instead of petitioner declarations? Yes. So traditionally, we would, in EDVA, maybe not even do any declaration and just kind of do the verification saying that, this is, these are true statements. The reason that we do declarations almost always now is that we have a lot of these cases in the Third Circuit. And so the conditions of confinement are quite relevant, and we want to describe people's, experiences in the conditions of confinement. EDVA, conditions of confinement, is not a factor. So it might not necessarily be important for your client to submit a declaration. And if it's too difficult for your client to actually submit a declaration themselves, then you could do an attorney declaration speaking to the factors. So I hope that answers your question. You can do this just like you do that in SDNY. As you probably know, the only evidence ICE is probably going to submit, and the only evidence they often submit in EDVA, is a declaration by an ICE officer talking about their immigration proceedings that they don't have direct knowledge of, which is arguably hearsay. So, not to say like, oh, we'll do it if you do it, but I think the standard of evidence for the government is not very high, and so it shouldn't be unreasonably high for us either. So e-filing through PACER, again, some folks may find this self-explanatory, but just to note, you basically create a civil case. In some courts, there's a dummy case number that then they assign a case number later. But for example, in EDVA, it just assigns you one right there when you file it. So it's a little easier. You file under the proper categories. You add the parties, which again is going to be the petitioner. They probably have not been a party to a federal case before, but maybe they have. The warden, DHS or its subsidiaries, and then the AG. You upload the documents, be that the petition and the exhibits. You pay a $5 fee. So in federal court, if folks don't know, generally for a complaint, it's $400 unless you get a fee waiver. But for habeas petitions, fortunately, it's just $5. And in my opinion, you should just pay that because it's just $5. I don't think it's a good idea to get into the informa pauperis thing because it's going to just delay things. You might as well just pay the $5. So you do that, then it's docketed, you get the stamped documents and you serve it. And we'll talk about service in just a second. So after filing, and this is a little bit court dependent. So I did want to talk about it, especially for the folks that do have experience in other courts, but maybe not locally. So EDVA is a little bit picky about this. So in general, I know some courts will kind of order the government to respond and then unilaterally serve the government with the petition themselves. Whereas in EDVA, that's more expected of you. So you have to file the petition, mail a printed copy to all of the respondents, and then prove service of the petition. And if you have questions about the quirks of that, please feel free to let me know. Then you're generally going to want to establish contact with the AUSA if you can. Start talking to them about the case, see if they're willing to agree to release or something short of a decision, and maybe notify other relevant parties. And then after filing, again, this is court dependent, but I did want to flag it. So for example, in EDVA, you generally need to show proof of service, and you generally need to specifically move the court to issue an order to show cause. In other words, they're not going to do so unilaterally. You have to ask for it, which can sometimes be advantageous because you can say, hey, I want you to give the government 7 days to respond and then schedule a hearing this many days after if you want a hearing. And often they will give you what you asked for, right? And so you can ask for a timeline that you think is amenable and then hope that they give you that. Whereas other courts have more standard orders. All right, I think that's it. I don't think that there are any outstanding questions for now, so we can have Kendra jump into the habeas compilation, and then we will be wrapped up by 2:30.
Excellent. Please feel free to keep sending questions, and thank you for letting us build the anticipation on this index. Give me a moment while I share my screen. Okay. Excellent. So again, this is our new favorite resource at CARE Coalition. We hope you find it incredibly helpful, especially after attending today's presentation. I'm going to walk you through it and show you how to use it. So this is a 73-page index of immigration habeas law that was prepared by our attorneys, interns, and law students. It has a little more information on CARE and the Impact Lab itself. As a refresher, these are the types of habeas relief that we covered today. The index is broken down in a table of contents. So you would first select which type of statute governs your client's detention. Then you would turn to see if there is a Circuit Court of Appeals test established. Then you would kind of go into the district court that you were litigating in. Again, venue lies where the non-citizen is detained. You have Austin's email here. Again, he's Care Coalition's go-to person for habeas law, so please feel free to email him for inquiries. You can also refer a habeas case to lab utilizing this link. We plan to update this index quarterly, and so after you've used it, I would greatly appreciate your feedback, especially on how to improve this index or cases that you believe should be added. So for any feedback on the index itself, my email address is here. So we are going to go through a hypothetical just to make sure everyone is aware of how to use these resources. So according to TRAC, there are over 1,000 people detained in Pennsylvania alone. So we're going to imagine that we are representing one of those detainees, perhaps someone detained under 1226C in the Middle District of Pennsylvania. So we would go to the table of contents, we would find 1226C. Again, which statute governs the non-citizen's detention might be up for debate. So this is assuming that both you and DHS agree that this is the governing statute. Pennsylvania is part of the Third Circuit along with Delaware and New Jersey. So first we would want to go to see if the Third Circuit Court of Appeal has anything to say. We would read through the Herman Santos decision, and I'm going to kind of like walk us through it, the main parts of this. So pretending we're reading this all together for the first time, Herman Santos has established this 4-part multi-factor reasonableness test that considers the length of detention, whether detention is likely to continue, the reasons for delay, and whether the conditions of confinement are meaningfully different. So with that in mind, that is the statute we are considering. So you would go back to the table of contents, and you would go to where your client is detained, where our client is detained, the Middle District of Pennsylvania. That brings us down here, where we can start thinking about how to apply what we learned from Herman Santos to this case. So in McDougall, this was a pro se petitioner who did not explain how detention center conditions differ from those found in a prison sentence. So they committed the error of not even briefing one of the 4 factors. The court further found that the length of the detention, here 13 months, is not sufficiently prolonged. So the Third Circuit does not adopt a clear 6-month plus rule. Most circuits don't, but that's just something we're going to keep in mind. Then we would go down to see if we could find more examples. This is an unpublished case, so it is not a binding legal authority, but you can still cite to it as persuasive authority. All the links will take you to Westlaw, where you can learn more. So in Skimming Smith, we learned that here, 3 of the 4 factors favored the petitioner, and they were granted a bond hearing. Okay, so 3 out of 4. We will go to the next one, Malid. All 4 weighed in his favor, so a bond hearing was ordered. Then scrolling down a little bit more to St. Jacques. Here, the detention was not prolonged. And only 1 factor was for the petitioner. So here, 3 of the 4 factors weighed for the government, and the habeas petition was denied. Then we get over here, again, 9 months, not prolonged enough. And here we learn that at least one of the factors is for the government. We might want to read more into this case, especially if the big question is whether the conditions of confinement are meaningfully different. Skimming a little bit more, Rad says 3 factors favor petitioner and the 3rd is neutral. Baghdad v. Dahl, here we have a 2-4 split. So the petitioner lost, 2 factors for him, 2 factors for the government. Bulishevi, again, just skimming. Here we have a different case. Again, we have a 2-4 split. Where 2 in favor of petitioner, 2 in favor of the government, and yet the petitioner was able to prevail. So I could keep going, with additional cases in the Middle District of Pennsylvania, but I hope you get the point. After skimming this index, we've learned that there is no bright line rule in the Third Circuit about how long detention has to be before it's considered prolonged. We learned from McDougall the importance of briefing each of the 4 factors. We also learned that it's possible to prevail and win a bond hearing, even if you only win on 2 factors. So you want to use these decisions to think about what are the minimum standards, what are the things I have to brief, and click through those cases, especially on the ones where you think one factor is questionable. Courts can also find that the factors are neutral. And so again, we hope that this index is useful to you as you consider the case law as it stands, in depending on which statute governs, which circuit you're in, and which district court you're in. That is the end of this section. Again, we'll be sending this out to everyone. Please email me your feedback if you feel so inclined so that we can make this resource better. And now we'll turn to any remaining questions.
Feel free to put in the chat, or if you would prefer to actually speak, I think you just raise your hand and then I can give you permission to talk or something like that. So any questions about the index or about this in general? We'll continue to hang around. I don't think there's any questions now. I know we threw a lot of information at you. Oh, here we go. Maybe there's one question. Okay, thank you, Shira. You gave a great presentation recently, so we're paying the favor. So yeah, we'll hang on for a little bit. But thank you all so much for attending. Again, feel free to email us with individual questions, and we will send out all these resources promptly. And again, we'll stay on for a couple minutes for questions, but thank you so much for attending. I think we still got some people who maybe forgot they were still in this. Oh, okay. Alex has a question. Hold on. Go for it, Alex.
Hey, thanks so much. Thanks for having us. I have a quick question about the 90-day period after withholding grant. I'm curious how you all have approached that, if you have filed anything, which it sounds like you have, in what form that came in, or was it directly to ICE? Did you file something with the court? Yeah, just curious about that.
Sure, absolutely. So can I just ask where, and forgive me if I recognize your name, where are you located?
New Jersey at AFSC.
Okay, AFSC. Okay, so your clients, we're talking about clients at Elizabeth or Moshannon, yeah?
Shannon, yeah.
Okay, yeah, so our litigation on the Cardi issue is in the Eastern District of Virginia. And that basically we're trying to certify a class arguing that the Washington field office is violating its own policy by holding people per se for 90 days and past 90 days sometimes without reviewing whether their detention is justified by exceptional circumstances. That's what the policy says. Individually though, right, and I think that's more of your question, we have brought individual habeas cases, release requests too, but to be honest with you, they don't really work, right? Because ICE either ignores them or, they deny them. So I think it's totally possible to gear up for habeas litigation by, maybe filing a release request under the post-order custody regulations, arguing removal is not reasonably foreseeable and or that not a flight risk or danger. So you can totally do that. In terms of the individual habeas petitions, I've done a few in Moshannon or in Western District of Pennsylvania for folks in Moshannon, and others are starting to do so. So far, and this has something to do with the AUSA up there being decent. They have just mooted them out, right? They don't want to deal with these cases. And so even within the 90-day removal period, we brought 2 at this point in Western District, arguing that removal is not reasonably foreseeable under Zovitis, also making our argument about the ICE policies and why they're violating them. And then ICE just releases the folks like a few days after filing. Apparently, the practice of the Philadelphia field office is that they will make an effort. The AUSA used the term "give it the old college try," which I found, disturbing. But will make an effort of third country removal, and then when they have concluded that it is not going to happen, which they should have in the first place, then they will release. And so basically a habeas petition just kind of speeds up that determination. They're not necessarily saying that they have to hold people for the full 90 days. I think other ICE offices would say that. So it's very unclear to me who's doing what, but that's my sense of the Philadelphia office. I'm not as sure about Elizabeth, but I've heard of some folks, it sounds like, that are being held past, although it seems a little shorter. Does that answer your question, or do you have a follow-up?
Yeah, that's great. Thanks so much. Appreciate it.
No problem. Absolutely. All right, there's still I think 21 people in the meeting. If you had a question, please just raise your hand and then I will unmute you. Otherwise, thanks for attending. What are the common reasons a habeas petition would be denied, and how long do these filings take start to finish? The most common reason a habeas petition would be denied is that the court determines, somewhat unfortunately arbitrarily, that detention is not sufficiently prolonged, right? So a lot of decisions will deny without prejudice. For example, they've been detained like 9 months, and a court, for example, Middle District of Pennsylvania, will say that's not long enough because the case has been proceeding more or less normally. So that's a pretty common posture to determine that detention is not long enough. Generally, when detention is pretty long, that will outweigh other factors, and the non-citizen will prevail. In the situation of like a non-citizen who can't be deported to their home country, is a Zovitis claim, those are more likely going to be denied because the court, if it gets a decision, will probably find some reason that removal is still reasonably foreseeable if ICE gives some speculative reason. So those are a little bit harder to prevail on in general, especially because they're asking for immediate release. How long do these filings take from start to finish? If you're working from a template, which we can maybe offer you, it shouldn't be that long, right? You can kind of plug and chug. I think it's more, you have to consider the whole length of the case, right? And so, it might take, I don't know, a week's worth or a couple days worth is probably better of work to draft and file the petition. But then there might be follow-up, right? You might have to reply to their response or argument, stuff like that. So it's pretty hard to predict. But I think in general, once you kind of grasp the factors, and if you have templates, and I guess if you use the index, I think it can be done relatively quickly, and it's not an overly complicated, area to brief. Hope that answers your question. All right, I think we're going to actually, let me just make sure that the recording is saved.